So here, the evidence begins with phone calls and texts from Mr. Mayers to Mr. Ephron, the complaining witness. I agree with Mr. Presbomic that tempers were heightened on both sides from both parties. The evidence then continues with video. The first video shown shows Mr. Ephron walking and meeting up with Mr. Mayers and two other friends, and immediately a gun is seen. And per the testimony, the defendant makes a threat. After the parties are separated, Mr. Ephron follows Mr. Mayers. The court can only question why he would do that, but as he indicated in his testimony, he was upset and he wanted to let Mr. Mayers know the full extent of his anger at that point. The next video shown shows the group regathered, and per the victim, Mr. Mayers fires at him. The video does show, the court agrees with the defense that you don't see an actual shooting on the video. Later in another section of video, you do hear two shots. In any event, Mr. Ephron does what appears to the court to be a dance around one of the other individuals to avoid being shot. In his testimony is that he was shot, and there was evidence of that via the clips that were shown of his knuckles and so forth. We then see a video of the victim returning to retrieve shell casings, and there's an issue as to whether or not that was him or not. We also see the video of law enforcement with several, I think it was 6 or 7, testified to by the detective officers on the scene. And they do have flashlights out, but query whether or not we see the full extent of any search at that point. In a preliminary hearing, the standard of proof is much different than what is required at trial. It is simply whether or not there is probable cause to believe that charged crimes are committed. It is a low burden. There's case authority that indicates all that is required is a scintilla of evidence. The fact that the victim was not seriously injured and in fact sustained apparently minor injuries is not to be considered by the court. The fact that the victim has filed a complaint in this matter does not weigh on whether or not a crime was committed either. Here, the totality of the video and testimonial evidence from the complaining witness is such that the court finds, in fact, there is sufficient evidence to find that charged crimes were committed and more than sufficient cause to believe that Mr. Mayers is guilty of having committed as charged. For purposes of preliminary hearing, he will be had to answer to counts 1 and 2. And he will be arraigned in 2 weeks, I think that's.
Your Honor, we discussed, can we approach on that?
We can.
Thanks.
The hold to answer date is December 4th. I know you're going to be away.
Right. I was going to ask, if we waive the, I don't know if you want me to approach on this, but if we waive the time for the arraignment, I know it's a defendant's right to be arraigned in a certain period of time. Could we do it at a later date?
I'm okay with that, Mr. Presbomic.
How late?
Which one? Whatever.
Uh,
Discuss. No, I want to discuss with him.
You can approach.
Yeah.
So the parties have agreed that the people will file the information on December 4th, which is the required date. It will be in Department 114. However, the arraignment will be on January 8th. Do the parties agree?
Yes, Your Honor, but I think he also has to waive the filing of the information, specifically.
Well, the information is going to be filed on December 4th.
Right. We've agreed to that.
Oh, no, I was planning on filing it on January the 8th, the day we come in for the arraignment.
I thought the whole issue was
if-
you didn't want to file it late. That's fine.
If
That's
they're
fine.
not gonna appear, it's not gonna be on their calendar, and I don't want some mistake happening with the, where that document.
Mr. Mayers, the court's going to ask if you're agreeable to waive time for the filing of the arraignment, which should be filed within 2 weeks, which would be December 4th until January 8th of 2024, and also waive time for your arraignment. Are you agreeable to both?
Yes. Yeah.
Thank you. Counsel Jones?
Yes, Your Honor.
Time is waived. The court should have all exhibits, and with that, the matter is concluded. Thank you.
Thanks, Your Honor.